how to protect your assets with private trust. I just feel like there's a lot of things going on right now. There's a lot of things that are changing, whether it's local or, federal government. There's a lot of things going on with currency, inflation. There's a lot of things going on with geopolitics. There are a lot of uncertainties. And when it comes to dealing with uncertainties everywhere, what we are told to do by the wise ones of societies, now and those that have come before us is to focus on what we can change and what we do have control over. So in that vein, I want to get real specific on how to protect your assets with a private trust. I'm going to go in a way that I never had before. I'm going to try to do it as fast as possible. This is a late episode. The schedule got backed up this week. So today is actually a Thursday versus a Wednesday. But I definitely wanted to get into this. This is the foundation. My name is Sot L, Seeker of Truth L, Speaker of Truth L. I do not give legal advice, relationship advice, tax advice, legal advice. I'm going to say it again. I don't, trading advice, investing advice. I don't give advice. But I do speak on what I know, and I do speak on what I have experience on. So with that being said, let's just jump into it. I do want to say this, though. A private trust is simply a trust created by way of a private contract, not via a state licensed lawyer or attorney, as the state is essentially public or actually public. The attorneys, the lawyers, they have state bar cards, i.e. some sort of license to practice law issued by the state. Their bar numbers. It's state, it's public, versus a private trust. It's just a private contract. Assets held in trust are protected from lawsuits, litigation, probate, and creditors. Most people think about this in the concept of, estate planning, right? Which essentially it is. But I guess most people think about estate planning as something as what old people do, or what you have to deal with when you're about to pass away, thinking about a will. Where I would say your estate is just all your stuff, everything that you own right now. And whether it's been taught against or not taught, period, it is very not only responsible, but beneficial to manage your estate while you're living. There's specific protections, specifically lawsuits, litigation, probate, and creditors. You see how probate was just one. Exchanging rather than selling assets to a trust could be a beneficial way to operate. I would say selling is more of a public commercial type behavior. Exchanging or bartering is more of a private behavior, but what do I know? I could be crazy. There are specific conditions. Assets must be unencumbered, meaning they cannot have a loan or a mortgage on them. They must be free and clear of any encumbering lien or claim. And arm's length and clean hands must be maintained at all times. But understanding what a private trust is, I think it's just very important. Let's get into it. Let me do the dance with the dancers. There we go. All right. welcome to the foundation.com. Make sure you check out welcome to the foundation.com. We are still offering the extended 50% off the setup fee for trustee training, private trustee training, trust administration, trust creation, trust education. These are skills, and this is knowledge that you will pass on to your heirs. But I want to be clear. These are skills and knowledge that you will utilize in your living life, not when you're terminal or when you're about to be out of here. No, during your living life. Or not. I could be crazy. I can't give you advice. I can't tell you what to do. You're a grown man and or woman. But 50% off. Email us, support at welcometothefoundation.com or admin at welcometothefoundation.com to get sorted with this. This is, I don't know. I got to check. I think we got like a week left on this. Also, you know what? Let me just get to it. Nope. Let me talk about this. Silver, currently at $103. It's currently moving around. To me, it kind of looks like it's been going sideways for the past couple days or so. You know, there's tops, there's bottoms, but overall, it's remaining in a specific range. I don't know. You got to get your hands on silver. There are fractional pieces of silver you can get your hands on. It's an industrial, plus it's a precious metal. It is used in industry and technology. It is scarce. You should do research. But first do the research, then go get some. Coin shops, local coin dealers, just do a search on the internet, and we buy gold spots. I would say are the best places to go. But that's the dance. That's not trading advice. Commercial advice, that's not advice. That's not advice. Private, irrevocable, non-grantor trusts. Legal definition, IRS treatment, and strategic advantage over statutory trusts. So private trusts versus statutory or public trusts, public statutes, public state statutes. This is a beautiful article that was put together. So let's just go through it real quick. A private trust, particularly a private irrevocable non-grantor trust. So irrevocable means the grantor cannot revoke any of the terms, has no power, and cannot revoke any of the property that was granted to the trust at the time of creation. The grantor has no power, and that freaks people out. I'm just going to be honest. That freaks people out. But I'm not going to say straight out, but I will speak on that, towards the end of the show. But also, irrevocable non-grantor trust. A grantor trust is what is known as this. The easiest representation of a grantor trust is a living trust, where the grantor is the trustee as well. It protects from probate, specific creditor situations, but most creditor, state situations, state actions, legal actions, litigation, doesn't matter because it's not a separate entity. But let's just move forward. It's a legal arrangement in which a grantor transfers property to a trustee who holds and manages it for the benefit of designated beneficiaries under terms established in the trust instrument. That instrument, also known as the trust contract. Unlike statutory trusts, public trusts, which are created and regulated under specific state trust statutes, such as the Delaware Statutory Trust Act, a private trust derives its validity and enforceability from the common law of trusts and the general contract law principles that predate most statutory frameworks. And I'm going to be more concise with this. From right here, the common law of trust and general contract law principles. The people have the unlimited right to contract. This is a common law right. It's called the common law right to contract. The common law was brought to the shores of America, and I would say couched in not only the Declaration of Independence, but also the Constitution for the United States of North America. But there's an unlimited right to contract, and we can get into status and how, with that unlimited right, we've been tricked, but that's not the topic of this episode. So the people in the United States, and generally the people in London, Britain, and predominantly Europe, everyone has the right to contract. It's general contract law principles, but derives from natural law. From a tax standpoint, the Internal Revenue Service treats a non-grantor private trust as a separate tax entity. That's important. Separate tax entity, subject to its own filing of income tax obligation. These trusts reach the highest federal tax bracket, which is 37%. I think it used to be 39.6%, but I guess it's lower, or I was mistaken. Could have been mistaken. At just $15,200 of taxable income, this unique tax profile, combined with the flexibility and confidentiality of private trust law, makes them an attractive alternative to statutory trust for certain individuals and families. And this is what I want to point out. Statutory trust is a public trust. Private trust is a contract trust. It's a trust that is established per the common law right to contract. So we got the legal standpoint. What is a private trust? Legally, a private trust is governed primarily, not exclusively, primarily, let's be clear, common law trust principles, which is restatement of trust. The third one, the trust instrument. This is the most important. And that should be first. The written declaration or agreement / contract, and applicable, and, determining whether it's applicable or not will be, subject to the contract itself. And this is where it gets important by being educated and trained properly with private contract trusts, and not just jumping out there, because there are so many ways that the state law applies its statutes to so-called private contract trust. And legitimately, they are private contract trusts, but within the indenture, within the contract itself, there must be specific terms, conditions, points of law to avoid the application of state trust law. This is very, very important, except where preempted by federal law. And then federal law, no state shall pass any law impairing the obligation of contracts. It's very important to understand the true elements, jurisdictionally speaking. Correct information, incorrectly applied, can get you hurt. I want to really emphasize this point. Moving forward, core elements. A trustee who holds title to the trust property, identifiable beneficiaries, trust property, also known as the trust res, or the corpus of the trust, intent to create a trust, which would be evidenced in the actual indenture or agreement itself, and a lawful purpose. There's case law guidelines in here. Economic substance. Trust must have economic substance beyond tax benefits. Sham trust shall be disregarded. This is case law. And then most people will research case law that speaks positively to their situation, but will not research case law that speaks or shows negative to their situation so that they can fix their situation. Very few people, unfortunately, review Supreme Court case law. Helvering versus Clifford addressed grantor control and reversionary interest in determining whether a trust is separate for tax purposes. It's very important that the grantor has no power over this trust. No power. And Commissioner versus the State of Bosch, federal tax authorities are not bound by lower state court determinations of trust validity if inconsistent with state law. So state can't tell with the Fed, hey, this is a trust, and the federal government will say, we'll be the judge of that. Basically, is how it's going down. We got IRS definition and tax standpoint. The IRS does not use the term private trust in the internal code. It does not. Private irrevocable non-grantor trust for tax purposes is separate from the grantor, files its own 1041, pays tax on retained. I'm going to say it one more time. Retained. Remember that. Income at trust tax rates, what was that, 27%? And may take deductions for certain trust level expenses, including depreciation. Ooh. IRS guidance and precedent confirms depreciation deductions are valid at trust level for income producing assets. It confirms bonus depreciation is available to properly structured irrevocable trust and clarifies allocation of depreciation within fiduciary returns. Listen, these are the structures of the wealthy. I'm just going to say it. It's the structures of the wealthy. And just because you got your hands on the knowledge of the wealthy, well, specifically the managers, the wealth managers of the wealthy, doesn't mean that you have the actual structure and language that the wealthy have within their contracts. Pros of a private trust over statutory trust. Creation, common law, plus trust instrument. No state filing requirement. I'm not an attorney. I just know this is absolutely true. I've been operating trust for over 10 years easily. That's absolutely true. Statutory trust created under specific state statutes requires a state filing. Ouch. Ouch, potatoes. Privacy. Private trust. High. Trust documents generally remain private. Generally. Well, because, they can be leaked. Lower on the privacy. Some filings may be public record. Flexibility. Terms defined almost entirely by the trust instrument. Very important. Statutory trust or public trust, bound by statutory framework and definitions, and statutes can be changed any session. The House and the Senate get together, and then the governor signs off on it, and boom. Every single state. No thanks. Jurisdictional choice can be cited in any state with favorable trust law. I'm going to go and say any jurisdiction. Or I'm just going to say, any jurisdiction with a public trust bound by the enacting state statutory terms. Once again, tax treatment, very flexible. I threw the very in there because it is. May elect grantor or non-grantor status, can optimize deductions, income retention, and reinvestment strategies. I like how they said that. Oh, that was kind of, hey. That was kind of swagged out. Hey, well, wait, that was kind of Riz, you know what I'm saying? No, I'm just playing. Generally treated as business entities for tax purposes unless electing trust treatment. This is statutory side. Asset protection, strong, especially in states with favorable spendthrift provisions, but if it's not governed by the state, if it's not bound by state statutory terms, then this especially doesn't very matter. We could just say strong. And then statutory trust varies by statute, some providing strong protection, others less so. Why choose a private trust? Confidentiality. And this is not holding back. Confidentiality, no public registration, keeps family wealth planning private. Control. The trust instrument, not statutory defaults, governs the terms. The trust instrument, not the state statutes, govern. Flexibility administration can be tailored to unique family or business needs without statutory limits. The business or purpose of the trust can be modified by the trust board of trustees very easily. Y'all can just make a phone call, man. Jurisdiction shopping, can choose governing law for favorable tax asset protection in perpetuity periods. Just X that. Perpetuity. Nope. That's not private. That's public. Only public structures can live in perpetuity. That goes against natural law. Tax planning opportunities, ability to retain income, strategically reinvest and utilize depreciation over time to recover tax burden lawfully. There's common confusions. Got a private trust and a real estate trust, investment trust, or a spendthrift trust. Answer: a private trust can be any. That's what I was saying. The purpose of the trust can be modified by the board of trustees. The purpose can be real estate. The purpose can be investment. The purpose can be spendthrift. Honestly, depending on the indenture, all three of those purposes can be reflected in one structure, one trust. In a private trust, these characteristics are determined entirely by the trust instrument. I'm telling you, if the settlor wants the trust to own real estate, invest in securities, and provide spendthrift protection, those powers and clauses can be written directly into the trust instrument. Hey, I'm going to be honest, I didn't read that, but I like how they summed that up. Public statutory trusts are tested and regulated. In contrast, public statutory trust, for example, a Delaware statutory trust. You got a Delaware trust? Yeah, it's a Delaware trust. Oops. You're the trustee? You just said that? Why'd you do that? You have real estate investment trust, REIT. Most people have heard of those. Or creatures of specific statutes and are regulated both by state law and, in some cases, federal securities law. Creatures of specific statutes. I really appreciate this language. Yeah, I mean, I'm going to save this. I like this. Regulation happens through state statutory compliance, must meet formal requirements of enabling statute, filing for formation documents with state agency, often the Secretary of State, ongoing compliance with statutory governance provisions, annual reports, registered agents, record keeping, etc. Federal compliance, if applicable. If applicable. I was going to say applicable. But, hey, I can say how I want, right? REITs must meet IRS qualification. Rules in the Internal Revenue Code to maintain REIT tax status. Certain public statutory trusts may be classified as investment companies under the Investment Company Act of 1940, triggering Securities Exchange Commission oversight. And I think one of these days I'll do an episode on how investors completely avoid this. And it is, a trust purpose to conduct investments, specific investments that would otherwise be regulated by the SEC, but is not because it's private. Testing for statutory criteria. Public statutory trusts are often tested against statutory definitions to ensure they qualify for special treatment. Failure to meet these tests can result in a loss of status, penalties, or dissolution. Dissolution, you're done. Your trust is done. We said it is. Private trusts do not have to pass a statutory test to exist. They are valid so long as they meet the common law elements of a trust and do not violate public policy. Did y'all know that? I feel like the more, when I first started doing this, 2015, I think it was. Before I made the foundation in 2016. Yeah. I assumed that as soon as people learned this, it was over. People were going to gravitate to it. People were going to grab it. It was just going to be such a fundamental distinction between how people operated just based off of me disseminating this information. And I think that, A, was short-sighted, and B, was very, very egotistical. Because, I'm thinking from my standpoint, if I read this, and I didn't know anything about private trusts, and there was a point where I didn't. If I read this, man, things like this wasn't available. But you would have to say less than this. Private trusts do not have to pass statutory tests to exist. They are valid so long as they meet the common law elements of trust and do not violate public policy. Wow. All right, so tell me more. How do I get a private trust? Their powers, whether over real estate investment or asset protection, come from the trust instrument itself rather than from satisfying a statutory qualification. And this will happen a lot. To be a state trust, you got it from an attorney, you paid $8,000 or $15,000 to an attorney and, whatever. And they change the statutes, or that trust acquires a lot of assets, and they will test that trust until they figure out a way to tax that trust and get some of the wealth or all of the wealth out of that trust, because it's a state structure. Practical tax implications and why the wealthy still use trust despite high retained income rates. It is true that non-grantor trusts face the top federal income tax bracket of 37% at just $15,200 of taxable income. On the surface, that may seem prohibitive. So why do high net worth individuals still use them? And how do they get high net worth in the first place? They were taught something by their parents or their uncle or their aunt or something like that. The answer, because the tax code itself contains numerous lawful strategies that allow trusts to lower, defer, or offset taxable income while protecting and preserving wealth. The high nominal tax rate is only part of the picture. The structuring, asset mix, and proactive planning are what determine the effective tax paid. And that's why my mentor would say, we take families and individuals. This is what he would say. I've heard him say it so many times. We take families and individuals from 50%, 40% tax liability to 25%, 10%, 5%, 2%, and effectively zero. He would always say effectively prior to saying zero. And sometimes he would say effectively prior to saying 5% and 2%. And he would say it, and it would over people's heads. Simply creating a private trust does not automatically produce tax savings. It is the ongoing administration and planning, analyzing what assets go into the trust, the types of income those assets produce, and how that income is allocated, distributed, reinvested, or set aside. That makes all the difference. And this is why trust education is so important. This is why people will be like, well, can we just buy a trust from y'all? No, absolutely not. That is irresponsible of the foundation. That's a violation. That's a breach of our fiduciary responsibility. Hands down. Because we know simply creating a private trust does not automatically produce tax savings. And in a lot of situations, if you are uneducated, it will put you in a worse situation than you were before you even started off. And people who do that, they turn off. They're like, I'm never going back to it because it's BS. It doesn't work. And you can never speak to those people again and have them really listen to what you're saying. And it's too bad ultimately for them, for their heirs, for their children, grandchildren, great-grandchildren, for the people they love, for the charitable activities and organizations that matter to them. It's really too bad. Examples of strategic planning: charitable set-asides, IRS Code Section 642, reinvestment into depreciable assets, purchasing income-producing property or equipment allows trust to take depreciation deductions, structuring charitable or religious organizations, aligning with the 501c3 or 508 can create pathways for income support, income chart, character analysis, and distribution to beneficiaries in lower tax brackets. Okay, so this one right here, right? And this is why, I don't really talk about it too much, but there's a thing called a private family foundation. It's 501c3 tax exempt. We are very, very familiar with the setting them up, structuring them, administering them. We are very familiar with it, but it is effectively and essentially a trust. It just has specific terms in the trust that allow it to receive 501c3 status. The Clinton Foundation, Bill and Melinda Gates Foundation, Carnegie Foundation, Rockefeller Foundation. These are the same types of structures. So part of being private and having a private trust, eventually you get to this level. You get to the 501c3 private family foundation. Private family foundation. You can look it up. 990 PF is the return it files. 990 P as in Paul, F as in Frank. 990 PF. And then this one right here. This one right here. These two, number 3 and number 5. I broach these topics all the time. I talk about this all the time, but I don't go as heavy into this. These fools got, I would never do this. This is hot. This is kind of, I've been, the way I was taught by my mentor, this is almost federal. I wouldn't, because every situation is different, but they got a whole map on here, man. For wealthy, the trust is not merely a container. Hold on, let me get back. Distributions. While retaining income may be strategic in some years, in others, passing income through to beneficiaries with lower rates can reduce overall family tax liability. Family tax, right? So I'm going to tell you this. These types of trusts, they're known as complex trusts. The IRS recognizes three types of trusts: simple, grantor, and complex. That's it. All these other terms doesn't matter. All these other adjectives doesn't matter. 3 types of trust. So this is a complex trust. A complex trust can disperse or donate 100% of its taxable income to a charity and receive a charitable deduction and then owe no tax. It can also disperse or distribute 100% of its taxable income to a beneficiary. And they'll say lower tax brackets or with lower rates, right? And that's important. I'm not going to go into that. But that's important. But if the trust distributes 100% of its tax liability to a beneficiary that it does not have any other income, legal and tax compliance requirements. And I feel like I'm just dropping all types of stuff. So I'm starting to feel weird, as though they're going to strike the show or something. Maybe I should just get out of my emotions. Must have economic substance. These are the legal requirements. This is federal. This is beyond state. Must file a timely 1041. Must maintain separate books, records, and bank accounts. Avoiding commingling. Cannot commingle. Cannot self-deal. Must follow trust instruments terms and avoid prohibited self-dealing. You cannot commingle. You cannot self-deal when administering trust. These are important principles that a lot of people innocently, accidentally, non-intentionally tear up. They just mess it all up. Asset protection trust. What is an asset protection trust? This is another website. Asset protection trust is an irrevocable legal vehicle specifically engineered to legally shield wealth from future unforeseen creditor claims. These specialized trust structures require the creator, known as the settlor, to formally and permanently relinquish direct ownership of the transferred assets. The primary mechanism of the asset protection trust is to place property beyond the legal reach of potential judgments or bankruptcy proceedings, creditors, I'm going to add on to it, litigators, just all of it. The settlor does not lose all benefit, however, as the structure is designed to allow the settlor to remain a permissible beneficiary under highly restricted terms. The effectiveness of an asset protection trust relies entirely on the legal separation between the person who funds the trust and the party who controls the trust assets. This separation must be genuine and absolute under prevailing trust law. Right? It gets into domestic and so on and so forth. But here, this is what I want to do, right? This is what I want to do. I want to speak on this, right? Okay. So I signed up for the trustee training, and you get this. If you've listened this long to the episode, this is the jewel. This is one of the jewels you're about to get from checking this episode out this long. Is this. Here's the hypothetical question. So I signed up for the training, yeah? Get all the trust set up, yeah? Open the bank accounts, yeah? Am I the grantor or the trustee? You're the trustee. Confusion, right? A lot of confusion. And the confusion is like, okay, so how am I the trustee? And I thought I was the grantor. I've been taught that I was the grantor. These are the two main things that people have an issue with. First one, right? Trustee. Trustees, if you are trained properly, educated properly with trust administration, if the trust is crafted properly, trustees have powers. Trustees have broad powers. Trustees can exchange their property into the trust. And they're like, okay, how do I do that? And who's the grantor? Anyone can be the grantor. Well, there has to be there has to be a trust res or a trust corpus before I sign on. Yes, of course. And that can be anything. But once you sign on as trustee and there's a power within the document that you have the right to exchange property into the trust, and the trust is a legal separate entity from you, and there's powers of management of all trust assets, powers of management of all trust assets, powers of management of all trust assets, that's when it clicks for people. You are the trustee. It's trustee training. You just need to sign on to a proper trust as a trustee. And there's certain positions that you need, but you got to talk to these people and tell them, like, listen, I just need you to be the grantor of this trust. But what I got to give up? It can be anything. But we have specific terms in the trust in describing what the grantor grants to the trust initially to make it lawful, to fall under those principles, those common law principles. The exchange is what people miss. People are always talking about sale. That's public. That's why I'm making these distinctions between public and private, right? Sales are public. Exchanges. Bartering is private. There's no need to use currency if you're bartering or if you're exchanging. Why are you using currency? Think about it. Why are you using currency if you're bartering and exchanging? The fact that you're using currency proves that this is some public commercial transaction. Barter, exchange. And we weren't taught this in school, but it clicks. I know for a lot of you, it was just like, blah, right? Okay, boom. This is a document from the trustee dissemination folder. It's about 2 gigs of Supreme Court case law. The majority of the case law, I pulled myself. And, you go down to the law library, you sign on to either LexisNexis or Westlaw Terminal, and you pull up the case. You find the case you're looking for, make sure it's the case you're looking for, and if you have a flash drive, you can download a PDF of the full case onto your flash drive. I used to go to the law library like weekly. I feel like it was like a year or two, and I feel like one summer it was weekly, definitely. But I used to be a regular at the law library. So a lot of those cases I pulled, we got the law dictionaries, Black's Law, Bouvier's Law dictionaries, which is required. We have a lot of different documents with regards to the proper administration. What else we got? We have, I'm pretty sure the Passing the Buck Volume 2 is in there. PDF. There's a lot. There's trust minute templates, trust template contracts. There's a lot of stuff in there. But this is one of the documents from the trustee dissemination folder, right? And this is transferring assets to a pure irrevocable trust. The authors refer to it as an unincorporated business organization, which I understand, unincorporated. It's not incorporated with the state. It's not registered with the state. A business organization. Whether, the business is asset protection or the business is, investment, or the business is, income producing assets, renting out land, so on and so forth. But I digress. Let's move forward. The unincorporated business organization, trust, is an organization born out of common law. It is different from a statutory trust in that it is a contractual business contract that has 100% legal ownership of assets vested in the trust. The more common statutory trust arrangement usually has legal ownership vested in the trustee and equitable ownership belonging to the named beneficiaries. The unincorporated business organization has beneficial interest certificate holders rather than beneficiaries. And these beneficial interest certificate holders have no equitable ownership and only restricted rights under the contract, i.e. they are entitled to a pro rata share of any trust distributions during the life of the trust and a pro rata share of any distributions upon the termination of the trust. Yeah, and distributions, and these would be per the determination of the Board of Trustees. So if the Board of Trustees determine that there will be no distribution, then there isn't. And that's can be forever. And this is what freaks people out. But you got to understand the structure and where you sit within the administration of the trust. What is your status? What is your position? However, since the trustees have have total discretionary power. They can decide if and when to ever make a distribution. The beneficial interest certificate holders can only hold their certificates and wait for such a distribution from the trustee. This rather weak position of the beneficial interest certificate holders is very important because it frustrates the IRS in their attempts to immediately tax exchanges of appreciated capital assets into the unincorporated business organization. Exchanges of assets of certificates. Okay? An exchange or sale would normally trigger a taxable event, but the actual date of the event is not yet determined. There hasn't been a distribution yet. You follow? Thus, these certificates are used to create an exchange of equal but indeterminable value. That is, the exchange of assets for certificates is deemed an equal exchange, but because there is no public market, i.e., as a stock market, that can put a value on these private certificates, and since the beneficial interest certificate holder, the beneficiary, won't receive any distribution of money or profits or currency until later at the discretion of the trustee, the exchange also must be viewed as having an indeterminable value. Since the certificates have no marketable value and receipt of any profits is at some unknown time in the future, the IRS is prevented from taxing the beneficial interest certificate holder on any profits at the time of the exchange. In such a case, the IRS must also wait. So if you haven't received any distribution, then there's no taxable event. Another way to view this issue, I'm just gonna keep reading because I don't want to, and I will. Another way to view this issue is that the beneficial interest certificate holder does not report any gain from the exchange, nor does the trust receiving the assets. It's not a taxable event. The tax basis in the property exchange into the trust is now reflected in the certificates and does not cause the certificates to take on a taxable status because they're private. They weren't issued or produced by any public organization or institution. They were produced by a private contractual entity. Y'all follow me, right? Where was I at? I'll just start from here. The tax basis in the property exchange into the trust is now reflected in the certificates and does not cause the certificates to take on a taxable status, but any tax liability can only be determined later if and when the beneficial interest certificate holder receives payment from the trust. If payment is never received, there will never be a tax. There are ample court cases and or citations to support the tax treatment of the exchange. And it goes on. And it goes on. But this is what I want to say. Like this is several pages, obviously. This is a 46-page document, and it goes into the actual mechanics of the exchange itself. But what I'm saying, what I'm sharing with y'all is that as a trustee, once you become trustee, you can exchange assets into the trust and receive beneficial certificates. That is not a taxable event. And if you have the proper education, trust administration, and trust indenture, the trustees have administrative control over all of the trust assets. And this right here is something I only tell people traditionally, generally, in a private consultation or if they're in trustee training. This connection right here. Now, hopefully you connected this. This clicked for you. But this is not something I usually talk about. But this is the mechanism that is misunderstood. So trustee, as a trustee, you can hold certificates of beneficial interest of the trust that you're administering. And that holds up. If it's a proper trust with proper language, proper jurisdiction within the language, proper powers for the trustees. Trustees are properly trained in private trust administration. If it is properly exchanged into the trust, if there's any creditors, litigation, lawsuits, whatever, they can't pierce the trust. The trust is a legal and separate, distinct entity from the trustee. But from the Internal Revenue Service standpoint, there's nothing for them to do because A, the exchange did not consist of Federal Reserve notes, which would have made it a sale. And B, there has been no realized gain. It was equal exchange. The trust got the property. The person that exchanged the property received the trust beneficial units or the trust capital units or the trust beneficial certificates. That's an equal exchange. That's not a taxable event. There's no sales tax on that. One, and it's valid. Now that property belongs to the trust, flat out. This is the mechanism by which not only how the wealthy maintain their wealth, but how they continue to perpetuate their wealth through generations. This is what we're trying to teach y'all here at the foundation, y'all. That's it. If you comprehend what we're trying to bring here, then it's easily obtained. Not only the structure, but the mechanics and education of how to administer the structure properly. 100%. There's fear involved in everything that you do that's new. Whether you're going down a water slide that's kind of tall, you're going on a roller coaster, you're flying in the air, anything new, you're going on a new job interview. There's fear involved in almost everything that you do that's new. And I'm not going to lie that there was fear involved when I started administering private trust. Absolutely. Absolutely. But I'm going to tell you, and y'all can go back and check, I have never had a real prolonged break from the foundation. I've been administering trust for over a decade. Lawfully. Trust brokerage accounts, private estates, checking accounts, even got into some credit. Titling vehicles, assets, all of it. Protection, all of it. All of it. And there was a point where I was like, man, am I going to get in trouble? This isn't, so I'm going behind the state's back. It's not, no. And part of trustee training is getting the knowledge, is getting the substantiation, is getting the case law, is getting the instruction. And seeing that, okay, so this is just a side of reality. This is a side of American wealth that I just didn't know about and it wasn't taught. Do your research. Rockefeller, John D. Rockefeller, endowed over 30 colleges before he passed. He was pivotal in endowing and setting up the General Education Board. But also, there's a John D. Rockefeller Foundation, man. So just because he established it was pivotal in establishing public educational systems and organizations that taught a lot of us, all of us went to a school that was under the Board of Education. All of us. And we were taught and learned the curriculum. But within that curriculum, I never learned in public school anything about a private family foundation or private contractual trust. But I know for a fact that his heirs and ancestors, his progeny, his descendants are still, at the minimum, beneficiaries of the wealth that he created and perpetuated. And I'm not trying to be like John D. Rockefeller. I'm not. That's just an example. It's an extreme example. And I think a lot of people, when they hear that, they're like, well, that's John D. Rockefeller. I'm just, listen, it's not about wealth. It's not about a whole bunch of currency that you have. It's about your assets. It's about your estate. Your estate. Your estate is all of your stuff. All of your stuff, including the debts. This is separating the debts and liabilities from the assets, from the things that you've exchanged your energy for, whether you're going to work or whatever you do. You exchanged your energy for it. You acquired it with the currency that you received. You essentially, quote, end quote, paid it off, and now it's yours. You should be able to pass that on to your heirs. You should be able to beneficially partake of your assets without being taxed, without the worries of it being sued, you being sued and losing it, having to sell it. These things are important in your estate. Your estate exists now. That's my main thing. Your estate exists now because you own things. You have things. You got phone chargers. That's part of your estate. Your phone. That's part of your estate. Your clothes. That's part of your estate. If you have a car, that's part of your estate. All your wealth is part of your estate. Even down to the pennies, that's part of your estate. All your books that you own, if you own books, part of your estate. It's your stuff. It's your socks. It's your shoes. Your shoes are a part of your estate. And people think about that. People think about the word estate associated with death. And that's not true. The yin and yang of it, there's death and life at the same time. So estates exist in life and death, but people pay attention to them mostly in death. And that's when they're dealing with probate. And that's terrible. I got a homie still dealing with probate. It's been like 3 years. It's ridiculous. It's absolutely ridiculous. No control. You have no control. That your heirs have no control. Your daughter, your son has no control. They just get some cookies. They, give little cookies here, and then there's a PR that's appointed that takes a part of the estate. There's a percentage that the state takes up from the estate for probating it. It's ridiculous. I obviously feel a certain way about this, but this is why we offer this, and this is why we're offering the half off. Admin at welcometothefoundation.com or support at welcometothefoundation.com. This is the education you get and more, and a lot more. And the main thing is the courage and the conviction. When you get around people that are doing this and have been doing this, and it's just every day to them. And then you start talking to, people normally that you deal with, and they're like, what are you talking about? That's only for rich people. And you start realizing the misconceptions that you had, not anyone else. It's really that the misconceptions you had. Like, wow. And then you get a year or two on, and now you start realizing the benefits. You're like, whoa. And then every time I hear, and I hear this from most people, I'm going to say between 80 and 85% of trustees that go through the training is, man, I wish I would have done this sooner. 10 years ago, 20 years ago, 5 years ago, 2 years ago. That's all I hear so much. I wish I would have done this sooner. I wish I would have known this sooner. I wish I would have came across you sooner. I had people, hey, I've been listening to you for years, and I just now hit you up and just now got a part of the training, and I wish I should have done this a long time ago, but I've been burned, and I didn't know. And so that right there, that's hey, that's how you protect your assets. I really jabbed out on that one. I'm just gonna be honest. I would suggest that you peep this several times, because honestly, I pulled no punches. But it's a quote new year, and there's a lot going on. There's a lot going on that we have no control over, but you definitely have control over your estate. You definitely have control over your estate, and you definitely will feel better once you learn trust administration and start implementing it. Once you learn trust administration, you go to the bank and you're like, can you open a trust account? And they're like, yeah, come on. And it's no problem. They don't look at you weird. You're like, wow. You realize how everyday this is. You realize how kind of like this is kind of a club, honestly. But the foundation, nah, man, we taking the covers off of this. And, you know, I'm going to be honest, even without the half off, this is very, very affordable. What you will retain in your energy, whether it's your energy that you're using with your body or your energy that you exchange for currency notes, you know, what you retain is I hear it all the time. So email admin@welcometothefoundation.com and support @welcometothefoundation.com. As always, I'm Sot L, Seeker of Truth L, Speaker of Truth L. Hey, yo. Incorrect information incorrectly applied can get you hurt. Correct information incorrectly applied can get you hurt. So learn how to correctly apply correct information. With that being said, y'all take care of yourself. Enjoy yourself. Make sure you say 10 things that you're thankful for before you go to sleep tonight and every night. It's important. And I'll catch y'all. We'll do current events tomorrow. Current events tomorrow, y'all. Peace.